Sir, I'm going to ask you to leave. You can't remove me from here just because I'm black.
Federal agents don't kick down doors unless they're sure. At least, that's what the public is supposed to believe. But on a quiet weekday morning, a successful black small business owner watched armed federal agents storm his workplace, handcuff him in front of his employees, and shut down everything he'd built. Based on a warrant that should never have existed. What happened next exposed a chain of errors, quiet assumptions, and institutional shortcuts that would cost the government $7.4 million. And the evidence came from their own paperwork. Federal agents, step away from the counter. Hands where we can see them. The voice cut through the warehouse like a gunshot. Customers froze. Employees dropped boxes mid-step. The sound of boots echoed across the concrete floor as agents in tactical vests poured through the front entrance. Darius Coleman didn't run. He didn't shout. He stood behind the front desk of Coleman Logistics Solutions, palms open, confused. "Officer, what is this about?" he asked calmly. "This is my business." An agent grabbed his arm, twisted it behind his back, and forced him to the ground. Plastic cuffs snapped tight around his wrists as employees screamed. The agents had come with a federal search warrant, or at least, that's what they claimed. What Darius didn't know, what none of them knew in that moment, was that the warrant authorizing this raid was legally defective, invalid, unenforceable, and the raid they were conducting would become the centerpiece of a federal civil trial that ended with a jury awarding $7.4 million in damages. Darius Coleman was 38 years old, a former warehouse supervisor who'd started Coleman Logistics Solutions from a rented storage unit 8 years earlier. His company handled regional freight coordination for small manufacturers. Nothing glamorous, but profitable, legal, and fully licensed. He employed 17 people, paid taxes, passed inspections, had never been arrested, and yet, on this morning, federal agents treated his business like a criminal enterprise. The raid was led by Special Agent Robert Kessler of the Federal Bureau of Investigation's Task Group, an interagency unit focused on financial crimes and interstate commerce violations. Kessler had been with the Bureau for 16 years and was known internally as aggressive, efficient, and results-driven. 2 months earlier, Kessler had received a tip. An anonymous source claimed Coleman Logistics was being used to launder proceeds for a larger fraud scheme involving falsified shipping records. The tip contained no documents, no transaction numbers, no named co-conspirators, just an assertion. Under normal circumstances, that wouldn't be enough. But Kessler had been under pressure. His unit hadn't produced a major case in over a year. Budgets were tight. Promotions were competitive. And when a tip landed on his desk naming a black-owned logistics company operating out of a converted warehouse in a transitional commercial area, his interest was immediate. Kessler began building a warrant application. He pulled partial bank data, without subpoena. He referenced outdated regulatory guidance that no longer applied to Darius's business model. He copied language from a previous warrant used in an unrelated case and modified the names. Most critically, he stated under oath that probable cause exists to believe evidence of financial crimes will be found on the premises. That statement was false, not fabricated out of malice, but constructed from assumptions, shortcuts, and omissions. The magistrate judge who signed the warrant never heard from Darius, never reviewed full financials, never saw the compliance certificates that were already on file with federal agencies. And so, at 9:14 a.m., federal agents stormed Coleman Logistics Solutions. Body cameras recorded everything. The footage showed agents sweeping desks, unplugging servers, seizing phones, and locking employees in a break room while they searched. Darius was kept cuffed on the floor for 47 minutes. At one point, an agent asked, "Where do you hide the second set of books?" Darius stared at him. "There are no second books." The cameras captured the confusion on his face, the fear in his employees' voices, the silence that followed when agents found nothing. No cash, no forged records, no illegal transactions. Still, the damage was done. By noon, the business was shut down. Clients were notified of a federal investigation. Contracts were suspended. Employees were sent home without answers. And Darius Coleman was released without charges. No apology, no explanation, just a warning. Don't leave town. 3 weeks later, the government quietly closed the investigation. But Darius's life didn't return to normal. Banks froze accounts. Vendors walked away. Rumors spread faster than facts. Coleman Logistics lost 60% of its business in 2 months. And then a letter arrived from a civil rights attorney named Laura Bennett. She had obtained a copy of the warrant, and she immediately saw the problem. The warrant cited statutes that didn't apply. It relied on regulatory rules repealed years earlier. And most damning of all, it claimed probable cause based on evidence that did not exist at the time it was sworn. The raid wasn't just aggressive, it was unconstitutional. And now, the government was about to learn that invalid warrants come with consequences. Laura Bennett didn't rush to file the lawsuit. She knew cases like this lived or died on paper, not outrage. Her first move was a federal records request, then another, then a subpoena. What came back painted a picture far worse than a single bad raid. Agent Robert Kessler's warrant application wasn't just sloppy. It was built on information he didn't legally have and conclusions he couldn't honestly support. Bank data referenced in the affidavit had been summarized from an internal database pull, accessed without judicial authorization. Emails showed Kessler had requested anything suspicious tied to Coleman Logistics before he had evidence of wrongdoing. One message stood out. "Business looks clean on paper," an analyst had written. Kessler replied, "Dig deeper. These setups rarely are." No follow-up evidence was ever found. Yet Kessler moved forward anyway. The magistrate judge who signed the warrant later testified that had he known the data was incomplete and that critical statutes cited were obsolete, he would never have approved the search. That testimony alone cracked the foundation of the government's defense. Darius Coleman filed suit in federal court under the Fourth Amendment and the Federal Tort Claims Act. The complaint alleged unlawful search and seizure, false imprisonment, abuse of process, and racial bias in investigative targeting. The government responded predictably. They argued qualified immunity, claimed good faith reliance on a signed warrant, framed the raid as a reasonable mistake. But Laura Bennett had something they couldn't explain away: the body camera footage. Unlike local police departments, federal task forces had recently implemented mandatory body cameras for high-risk operations. Kessler's unit complied, and those cameras recorded everything. The jury would later see footage of agents entering calmly, then escalating without provocation. They would hear Darius asking simple questions and receiving none. They would watch agents search for evidence they clearly expected to find, only to come up empty again and again. At one point, an agent muttered, "There's nothing here." Another replied, "Keep looking." The cameras also captured something more subtle: assumptions. Comments about the building being too nice for a business like this. Questions about who really funds this place. A remark about Darius not fitting the profile of someone who just runs logistics. None of it criminal. All of it revealing. During discovery, Bennett deposed Agent Kessler for 7 hours. Under oath, he admitted he never interviewed Darius before seeking the warrant, never subpoenaed full financial records, never consulted regulatory specialists who could have clarified the business model. When asked why, his answer was short: "We needed to act quickly." The jury would later hear Bennett ask the follow-up: "Quickly to stop what crime?" Kessler had no answer. As the trial approached, the government offered to settle, first for $900,000, then $1.8 million. Darius refused. By then, Coleman Logistics Solutions was barely surviving. He'd taken out personal loans to keep employees paid. His name still appeared in online articles linking him to a federal investigation, even though no charges had ever been filed. He wanted more than money. He wanted the truth on the record. The trial began 14 months after the raid. Federal prosecutors argued the agents acted within their authority and relied on a facially valid warrant. Bennett dismantled that claim piece by piece. She showed the jury the warrant, highlighted the incorrect statutes, called experts who testified the cited regulations had been repealed years earlier, presented emails proving Kessler knew his evidence was thin. Then she played the footage. The courtroom watched the raid unfold from the agent's own perspective. The confusion, the force, the empty desks and blank hard drives. The moment Darius was uncuffed without explanation. One juror later said you could feel the room shift when the footage ended. The defense tried to argue intent didn't matter. Bennett disagreed. "This case isn't about a mistake," she told the jury. "It's about shortcuts, about assumptions, and about what happens when federal power is used without constitutional discipline." She reminded them that the Fourth Amendment doesn't exist to protect criminals. It exists to protect everyone, including people who look like Darius Coleman. After 8 days of testimony, the case went to the jury. They deliberated for just under 6 hours. The verdict was unanimous. The warrant was invalid. The raid was unlawful. The detention was unconstitutional. The damages phase began immediately, and that's when the number shocked everyone. The jury didn't hesitate on damages. They had seen the financial records, heard from former clients, listened as Darius's accountant explained how a profitable, stable business collapsed after a single morning raid. The foreperson read the numbers slowly. Lost contracts, $2.9 million. Reputational damage, $1.7 million. Emotional distress, $900,000. Punitive damages, $1.9 million. Total award, $7.4 million. The courtroom went silent. Darius didn't celebrate. He sat still, eyes down, hands clasped. The money couldn't undo what had happened. It couldn't give back the months of anxiety, the sleepless nights, the conversations with employees he had to let go. But it did something else. It put accountability on record. The judge denied the government's post-trial motions within weeks. In a sharply worded opinion, he wrote that the warrant application showed reckless disregard for constitutional requirements, and that qualified immunity did not apply when agents relied on facts they knew were incomplete or misleading. The ruling sent shockwaves through federal law enforcement circles. Internal reviews followed. Agent Robert Kessler was placed on administrative leave pending investigation. Emails obtained later showed supervisors questioning why an unverified tip had been elevated to a full tactical raid. One line from a review memo stood out. "We assumed probable cause instead of proving it." The Department of Justice issued a statement acknowledging the verdict but denying racial bias. Privately, however, policy changes were already in motion. Mandatory pre-raid legal review for financial crimes, independent verification of anonymous tips, updated warrant training emphasizing current statutes only, body camera audits for federal task forces. None of those reforms existed before Darius Coleman sued. Kessler resigned 6 months later. He never admitted wrongdoing. In a brief exit interview, he claimed the system had overcorrected and that agents were now hesitant to act. But the jury had made something clear. Hesitation is exactly what the Constitution demands. Darius used part of the settlement to pay off debts and rehire staff. Coleman Logistics Solutions reopened in a smaller facility, quieter, less visible. He also did something unexpected. He funded a legal clinic for small business owners, people who didn't have attorneys on speed dial, people who didn't know what to do when a badge and a warrant showed up at their door. At the clinic's opening, Darius spoke briefly. "I followed the rules," he said, "and I still lost everything for a while. This isn't about hating law enforcement. It's about making sure power has limits." The body camera footage from the raid is now used in federal training seminars. Not as an example of good policing, but as a warning. Because the agents thought the warrant protected them. They believed a judge's signature made everything legal. They forgot that warrants only matter if they're valid, and that courts will look behind the paper. The jury did. And when they did, they saw a raid built on assumptions, shortcuts, and quiet bias. One morning, one invalid warrant, one business destroyed, and a $7.4 million reminder that constitutional rights don't disappear just because federal agents show up. Years later, the raid on Coleman Logistics Solutions is still cited in federal court opinions. Not because it was unusual, but because it was exposed. Most invalid warrants never lead to jury trials. Most raids never face public scrutiny. Businesses quietly collapse, reputations quietly die, and the paperwork moves on. What made Darius Coleman's case different was evidence. The warrant, the emails, the body cameras. Every step federal agents assumed would protect them ended up documenting their failure. During post-trial hearings, one appellate judge summarized the case bluntly. "A warrant is not a shield when it is built on omissions, outdated law, and unverified assumptions." That sentence now appears in multiple training manuals. The government did not appeal. Their attorneys knew the risk. An appellate ruling could have expanded liability nationwide. Letting the verdict stand quietly was safer than setting precedent in higher courts. But precedent was already set in practice. Federal agencies began reviewing old warrants tied to anonymous tips. Several pending raids were delayed or canceled after internal legal reviews flagged insufficient probable cause. None of that was publicized, but it happened. Darius Coleman never became a media figure. He declined most interviews. He didn't write a book. He didn't start a movement. He went back to work. People who knew him noticed a change. He was more guarded, less trusting. He installed security cameras, kept copies of compliance documents on his phone and in his car. Not because he was guilty, because he had learned how fragile legitimacy could be. In private conversations, Darius would say the same thing. "They didn't raid me because I broke the law. They raided me because they thought they'd find something." That assumption, the belief that suspicion is enough, was what the jury rejected. The body camera footage from the raid ends the same way every time it's shown. Agents walking out. No evidence bags, no arrests, no explanations. Just a business in disarray and a man standing in the middle of it, watching everything he built get labeled a crime scene. The agents uploaded their footage, filed their reports, and went home, believing procedure had protected them. They were wrong because procedure only works when it's honest, and warrants only mean something when they're valid. A single invalid warrant cost the government $7.4 million. It cost Darius Coleman nearly everything, and it reminded the courts of something fundamental. Federal power is vast, but it is not unlimited. If you believe federal agents should be held accountable when they violate constitutional rights, and that warrants must mean more than paper, subscribe and turn on notifications. Tomorrow, we're covering another case where the government assumed authority and the evidence proved otherwise.